Please be seated. The next case on the calendar is Jacobs versus Clarkwestern Building System et al. Again, we've allotted 15 minutes to decide. And Ms. Questo, I know you know how the clock works, so I won't explain it again.
Thank you. May it please the Court, I'm Wendy LaQuasto of Fox and LaQuasto. I'm here today representing appellant Kathleen Jacobs. I'd like to reserve 4 minutes for rebuttal. There's two issues raised in this appeal. The second issue has to do with the attorney's fees, and unless there's any questions on that, I'm just going to stand on my briefs. On the first point, claimant maintains that the JCC erred as a matter of law and fact in denying temporary partial disability by applying the wrong legal test to determine entitlement to TPD, by erroneously shifting the burden on voluntary limitation of income, and by finding that claimant voluntarily resigned for personal reasons. On the correct legal test aspect of this issue, claimant maintains that the JCC fashioned a test to determine entitlement to TPD by relying upon the statutory definition of disability in 440.02 sub 13, which says that a claimant has to be unable to do the same employment or any other kind of employment. Claimant maintains that the correct test is set out in the statute dealing with TPD, and that's 440.15.4a, which simply says that you have to not be at MMI and that your physical limitations preclude you from returning to your prior employment. So claimant maintains that's satisfied. She handled heavy work, worked on a forklift and did manual labor that required her to lift over 50 pounds. It's undisputed she had a herniated disc. It's undisputed that she had limitations from the get-go after the accident that would preclude her from doing her job. That's really not a dispute. So claimant maintains that she satisfied her burden to receive temporary partial disability benefits. The analysis then turns to whether she voluntarily quit her job and voluntary limitations. And at that point, the burden shifts to the employer carrier to show that she did that she voluntarily limited their income. And we submit that the evidence shows that she did not voluntarily quit, and that they did not show that there was jobs within her restrictions available for her. The first job that they offered her was a painting job, painting rails and decks and steps, which she could do while seated in an office chair. And she could do that. She said she could do that, but she painted everything that she could paint in that job, and that job was no longer available. And then the next job that they gave to her was painting warehouse walls. She had to carry 5-gallon pails of paint to do that. She had to use a 6-foot extension. She had to get down on her hands and knees to paint trim on the floor. She had to reach up to paint these walls.
Ms. LaQuasto, this is all certainly part of the evidence in the case. But what about Ms. Bailey's testimony?
I'm sorry, I didn't hear the lead-in to that.
I mean, what you're telling us is all part of the evidence in the case, but the issue is that you're talking about now is a CSE issue, and which is whether she voluntarily resigned. And Ms. Bailey, it seemed to me, testified at some length regarding the flexible light-duty programs that would have been available had your client simply gone to her and said, I don't feel I can do the jobs you're having me do now. Isn't that CSE to support the decision?
No, it's not. Under the Myers case, I made my analogy in the brief to the Myers case. This is a person, Ms. Bailey, who says, well, if I coulda, shoulda, maybe kind of testimony. She doesn't present anybody that says that actually said that those two jobs that claimant couldn't perform were within her restrictions. She doesn't, so they don't offer anything to show that. She doesn't know those jobs. She didn't assign those jobs to claimant. She also didn't. Well,
didn't she expressly testify that if claimant had told her she was having problems she would have seen to it that the job was modified to fit her physical restrictions. Didn't she say precisely that?
She did say that. And let me point out,
why isn't that CSE?
because there's nothing in the record to show that claimant had to talk to Ms. Bailey about what her job was. In fact, the undisputed evidence in the record is that claimant said, I was told that if I had a problem with my job, I needed to go to my supervisor first, and my supervisor would then take whatever issues I had to where they needed to go. This is precisely what she did.
But there was no evidence that she ever told any of the supervisors.
Oh, that's not supported, but the record shows, and she testified it was undisputed, that she told, when she first got the painting job of painting the walls, that she told Bill Ayers, her immediate supervisor, I can't do this, this is making my back hurt, this is making my leg hurt, I can't do this work. She testified he wasn't happy about that. He took her to the plant manager, who also was not happy with that, and the plant manager told her, if you can't do, we would never give you a job that would endanger your health, and if you don't think that you can do this, maybe you ought to find another position. That's really telling a person that you need to do this job or you need to find another job.
Didn't your client testify that when she told her supervisor she couldn't do the paint work, the supervisor said, okay, we'll find you another job?
They said...
Did she testify to that?
She testified that when she told Ayers she couldn't do the job, he was not happy. He took her to the plant manager, who she said was not happy, and he said, we wouldn't give you a job that would endanger your health. If you don't think that this job is something you can do, maybe you should find another position. And they didn't find another position for her. I mean, I think that's critical. That's really a very, I don't even think it's a subtle way of saying, you know what, if you don't want this job, maybe you ought to quit and find a job you can do.
So you're telling us that the supervisor did not say to her, if you can't do this job, we will find you substitute work.
Ms. Bailey might have said that, but she wasn't.
You're saying the claimant did not say that. Did the claimant testify that when she told her supervisor she couldn't do the paint job, the supervisor said, if you can't do it, we'll find you substitute work?
Now, we'll find you. Maybe you should find another position. I'd be happy to look in the record for it.
Try pages 17 and 18 of Volume 1.
She complained a second time to her supervisor about the job, too, when she did the forklift, and was greeted with the same kind of response.
But at that point, she was released with no restrictions by her doctor, wasn't she?
It was a trial run at regular work.
At her request.
At her request, because she had worked for approximately months doing a job that was killing her. Did you have this is the second painting job, did you experience any physical problems being able to do the work? Yes, I did. What type of problems? Pain in my leg, pain in my back, just all over, uncomfortable. Did you do anything about it? Yes, I did. I spoke to Mr. Ayers about it again. Mr. Ayers was your supervisor? Yes. In your deposition, you mentioned Tiny, that's Bill. Okay, same person. And what was his response? His response was he took me up to Mr. Godfrey. Who's Mr. Godfrey? He's the plant manager. And did you make the same complaint to him? Same complaint to Mr. Godfrey. And what was his response? He wasn't very positive. Can you tell me what it was? He, quote, he told me that there would be nothing he would ever do to jeopardize my health, and that if I felt that I was doing this wrong, maybe I ought to think about a different position. Did you get a different position while I was at Clark? No. So that's what I'm maintaining. When she complained to the person
You're reading different position as leave here and get a job somewhere else?
When she complains to Mr. Ayers later on about the forklift job, he says, it's your choice. I'm not going to have this on my hands. Now, I read this as a person as being told, like, if you don't think that you can do this job that we're giving you, then you need to find another job. And I think that that's equivalent of telling you, put up, shut up, and take what we give you. That's not an accommodation. There's really no dispute that that second painting job was outside her restrictions. She couldn't carry those heavy things of paint. She couldn't stand on her feet all day. Those are the restrictions that were in place. She was not supposed to be on her feet all day, and this job of painting warehouse walls required her to do that. And when she complained, as she was supposed to complain to her supervisor, that was the response she got. She didn't get another job. Now, they bring in Miss Bailey later on.
She did get another job, didn't she?
Finally, she goes to her doctor and says, when she's worked for a month doing a job that's killing her, she says to her doctor, I think the inference is reasonable, that she needs to have some sort of release so that she can try to get some other kind of job so that it won't kill her. And then he says, okay, you can have a trial run at forklift. She goes. They put her on a forklift that doesn't have rear view mirrors. She's got to be twisting. She complains to her employer, her supervisor that day, and he says...
She ultimately says that she's resigning, quote, for personal reasons, close quote. If she couldn't do the work, why didn't she say, I'm resigning because I'm physically unable to do the job?
Well, that would have been great, but that's not what she did. And she told she told people, her doctors.
Doesn't that create an issue for the trier of fact?
I think that once you get to the point of, even if you want to accept the fact that she quit for personal reasons, you still get into the analysis of how you're entitled to TPD. And if you look at paragraphs 18 and 19 of the order, this JCC applied the wrong legal test. I don't think that we can determine under the facts, under this case, would this JCC have reached the same result if she had applied the correct legal analysis? And so, at the very least, I think you need to remand it with instructions to reconsider it with a proper analysis, even if you want to accept she quit for personal reasons, because the JCC acknowledges the fact that even quitting for personal reasons doesn't preclude you forever from receiving temporary benefits. I see I'm into my rebuttal. I'll reserve.
May it please the Court. My name is Nicolette Sambus, and I represent Travelers Indemnity Insurance Company and Clarkwestern Building Systems. Now, I know the facts have been thoroughly described in both of the parties' briefs, but I feel that highlighting the timeline actually involved in this case is illuminating to actually portray what happened in the case. The claimant was involved in an accident on August 14, 2006. She injured her back. It was accepted as compensable. She was provided medical treatment that same day. She was given light-duty restrictions, goes to the employer, is offered a job within her light-duty restrictions. She was offered a job painting railings and stairs, which she confirmed is within her restrictions. All the railings are painted. She goes through the stairs. She paints the stairs. Then she's given another light-duty job that's painting the walls on the warehouse. There's no medical testimony that indicates that the painting the walls on the warehouse is outside of the restrictions that Dr. Eisen gave her. She continues that job and, in fact, goes back to Dr. Eisen, her treating orthopedic doctor, and says, I'm feeling better. Can I have less restrictive work restrictions? Dr. Eisen says, okay, I feel that's appropriate. I'll give you a trial of regular duty work. Simply says you can't work on a crane, but says you can work on a forklift. That's what the actual work restriction, the DWC 25 references. So the employer, again, accommodates another light duty restriction, gives her a job on a forklift. Then the very next day, on September 15th, 2006, she resigns. She comes to Ms. Bailey. She says, I'm going to resign for personal reasons. She doesn't specify why. She doesn't say the job's outside my restrictions. The only thing she says is personal reasons. So then on September 21st, 2006, she all of a sudden has now filled out an application to go to Everest University. Now, if we're to assume that the claimant wasn't predisposed to go to college prior to her voluntary resignation, then we have to assume that in those 6 days, between September 15th when she resigned to September 21st when she filled out the application, she went through the process of picking, I'm going to go to school, I'm going to go to this college, I'm going to go to this program, and I'm going to do a 2-year AA program. She fills out the application, goes to school on October 16th. Now, I know these are all issues that is for the trier of fact to decide. This is factual determinations that the judge of compensation claims made determinations at the final hearing. She made the decision that the claimant was predisposed to already going to college before she voluntarily resigned, and that her resignation was independent of her injuries. Throughout the answer brief, and we referenced the fact that the JCC is the actual factual determinations, is a trier of fact, and her findings are to be supported by competent substantial evidence. You can see that in Ullman v. City of Tampa Parks Department, 625 Southern 2nd, 868, where the JCC's factual findings must be sustained if permitted by any view of the evidence. And it's the employer carries position that this is exactly what happened here today. The ultimate issue in this matter is a question of fact, whether the judge had competent substantial evidence to support her finding that the claimant did not meet her burden of proof for temporary partial disability benefits. Now, the claimant tries to argue that the JCC used an incorrect legal standard. That's not the case here. The JCC was proper in its application of 440.15 subsection 4 dealing with temporary partial disability benefits, and incorporated the actual definition of disability in 440.02 subsection 13. The JCC encompassed the totality of the circumstances, which is the exact requirement that this court has referenced in numerous cases, including Arnold v. Florida Blood Centers, which is 949 Southern 2nd 242, and also Interim Services v. Levy, which is actually cited in the claimant's brief. It's the totality of the circumstances that makes the JCC's decision supported by competent substantial evidence. The JCC's decision was correct for three reasons. First, the application of temporary partial disability benefits was supported by the legislator's intent that's laid out in 440.015. Second, the factual determinations are clearly supported by competent substantial evidence. And third, the claimant failed to meet her burden of proof. It's her burden. The burden never shifted to the employer because there was nothing to support the fact that her lost wages were causally related to her industrial accident and the light duty restrictions she was given by her doctors. Going into the legislative intent, 440.015 deals with cites, I'm going to quote from the statute, that the purpose of the workers' compensation statute is to facilitate the claimant's return to gainful reemployment at a reasonable cost to the employer. This is reiterated by the case that recently decided by this court in October 2009, the Moore v. ServiceMaster, where the court goes into detail that it's the legislator's purpose to promote the employer to offer reemployment to its injured workers, and that's exactly what our employer did here. We offered the claimant 3 different jobs. When her restrictions changed, she got a new work restriction. She was allowed to work on the forklift. It was the claimant's decision to voluntarily resign from her position for personal reasons and then ultimately go back to school. It's commendable that the claimant went back to school, but it's not the carrier's responsibility to pay for the claimant to go back to school during that time. The workers' compensation system is not designed to allow a claimant to simply resign from an employer who is offering these light-duty restrictions that the legislator is trying to promote with employers, and then allow her to go home and collect a check, or in this case, to go to college, collect a check, and then finish college when she is still able to earn those pre-accident wages. There's nothing in the evidence that suggests that the claimant needed to go to college to earn her pre-accident wages. In fact, her own vocational expert testified that the claimant was capable of earning her pre-accident wages even prior to going to college. There was no need for it, and the employer was offering her job, earning her same wages. We offered her 3 different light-duty jobs, and she chose to voluntarily resign. Now, in the claimant's initial brief, she references 3 specific cases: Burger King versus Nicholas, and then also Ringling Brothers and Interim Services versus Levy. In the Burger King case, it talks about the claimant's ability to return to a prior job. And it's my understanding that the claimant's trying to argue that because she couldn't return to her prior job, she wasn't able to go, she met her burden of proof. And that's not the case. The fact that the claimant couldn't return to her prior job, the employer carrier doesn't dispute. She was a material handler, she got light duty restrictions, she couldn't do that job anymore. But that doesn't mean she met her burden of proof. That doesn't establish temporary partial disability benefits. Burger King versus Nicholas, that's 580 Southern 2nd 656, indicates that the claimant's ability to return to her prior job is a contributing factor. It's not the sole factor, And again, that case cites to Ringling Brothers, which talks about the totality of the circumstances. The JCC has to take into account all the factors in determining whether the claimant has met his or her burden of proof. In Ringling Brothers, the claimant was acrobat. He is injured on the job, working for the circus, ended up not being able to return to his job as an acrobat. The reason this court awarded temporary partial disability benefits is because he had a valid work search. He participated in a work search, couldn't go back to his prior job. It's all those factors that were taken into account when the JCC decided that temporary partial disability benefits were awardable. The work search wasn't present here. The JCC determined that the claimant did not participate in a valid work search. She didn't look for work after she voluntarily resigned. In fact, her own vocational experts confirmed, that's on page 198 of the record, that the claimant went back to school without participating in any type of work search. There's indications in the record from the claimant's testimony that she looked for work at 2 different employers. There's no indication when she participated in that work search. There's no evidence that she actually filled out applications at those 2 employers or when she did that, because she went to a 2-year program of full-time employment and then decided to continue on and finish her BA degree and get a 4-year degree. No evidence to support a work search, and that's exactly what the JCC determined, and it's a factual determination that was made by the judge and should be upheld by this court as well. Now, the court also indicates that the claimant also indicates that the JCC improperly used the word disability when talking about temporary partial. 440.15.4a does talk about the claimant's ability to return to work. But if you read the entire temporary partial disability statute in its entirety, 440.15.4e talks about that it's the claimant's ability, the claimant is entitled to temporary partial disability benefits during the time that she remains disabled, not to exceed 104 weeks. Clearly, the term disability is referenced in the statute. It's in the entire statute, and the legislator has intended the whole Chapter 440 to be read as a whole. You can't distinguish it out. So by the JCC applying the definition of disability, which is the incapacity because of the injury to earn in the same or any other employment the pre-accident wages, she was correct. And that brings me back to the overall purpose of this case. It's solely a question of fact. Was the JCC correct and supported by competent substantial evidence to establish that the claimant never met her burden of proof? And to go into further detail about why the JCC's factual determination was correct, the employer, first, was successful in offering her 3 different light-duty jobs. Second, they were still willing to offer her this light-duty job, and yet, and that's evidenced by testimony from Ms. Bailey. And then third, the claimant made the pre-existing decision to quit and to go back to school. That's evidenced by the JCC's determination and the timeline that I referenced earlier. The fact that she quit on September 15, 2006, filled out her application, made the decision to go to school, started a full-time 2-year program only 6 days later, was further evidence for the JCC to determine that there was competent substantial evidence that the claimant voluntarily resigned from her position with the employer who was offering a light-duty job within her restrictions. Now, I understand that just because the claimant voluntarily resigned doesn't mean that she's entitled to, that she's no longer entitled to temporary partial, but again, it goes back to the totality of the circumstances. The claimant voluntarily resigned, and then she decided she did not participate in a valid work search. Again, there's no requirement for a job search in the statute any longer, but again, it's a factor for the court to consider when making a determination as to whether there's entitlement to temporary partial disability benefits. Now, the factual findings by the JCC should not be reweighed by this court, and the employer carrier respectfully requests this court to affirm the JCC's prior decision. There's evident, all the cases support the fact that the causal connection between an injury and industrial and the ability to return back to work is a question of fact, and that's all that's involved here. It's a simple issue of a question of fact and whether or not competent substantial evidence supports the JCC's decision. Thank you.
Thank you. Mr. Quasta?
Just a few things that I would like to point out, that when Dr. Eisen released claimant to try the forklift work on 9/14. That was at the same time he was making a referral to pain management, and it was just a week before that the MRI had come back that showed that she had herniated disc.
So what?
Well,
Really, so what?
because you said earlier that he released her to work without any restrictions, and he
Didn't
referred her
release
for
to
pain
work
management.
without any restrictions? Isn't that what he did at her request?
A trial run and a referral to pain management. I don't think that that's somebody that you can just go out and do a job. I think that there are some, the Delchamps case, which is 659-341, there the employer similarly testified that they would be willing to find a job for claimant within their restrictions, but they didn't identify a job. That's the same thing that Bailey's saying here. I would be willing to find something, but they don't offer a specific
If all of
job.
that is true, you still have the fact that the JCC concluded she resigned for personal reasons.
And I go back to my initial argument that she has applied the wrong legal analysis in 18 and 19. There are findings in those two paragraphs that are unsupported. She found that claimant resigned without exhausting light duty. Well, you know, she did two jobs that were outside of her restrictions. You don't need medical evidence to show that your jobs are outside your medical restrictions. Her unrefuted testimony was that she couldn't do them. And when you look at the restrictions that Dr. Eisen had applied to her, it's common sense tells you that you couldn't do those jobs. The JCC also found in those two paragraphs that claimant did not conduct a job search. Well, the unrefuted testimony was that she went to the police department, that she went to the sheriff, and that she went to the unemployment office. So she did.
6 days after she resigned, she applied to become a full-time college student.
You know, this lady had done manual labor, heavy lifting, and she could no longer do it.
Why couldn't the JCC conclude from that she did in fact resign for personal reasons?
I think that it's really like a Whitaker-Myers case, that you're looking at a situation where a person has complained, as she's supposed to complain to her supervisor about inability to do a job, and she's basically told that she needs to find herself another position. So you know what? She decided, this job, they're not listening to me, I'm hurting my back even more, I already have a herniated disc and a problem with my leg, I'm going to have to come up with a new plan.
That's certainly one possible interpretation of the evidence. Unfortunately, the JCC interpreted the evidence in a different way.
I understand that then you need to send it back to have her correct her incorrect findings, because she found that there was no job search. She found that she exhausted the light work that was offered, and that she applied the wrong legal analysis. And let her make an appropriate findings with a correct legal analysis. I think what the EC is doing is asking this court to shift the burden of injured employees to society or to the claimant themselves. Thank you. I ask you to reverse and remand.
The final case today is